Senhoras e senhores, sejam todos bem-vindos e bem-vindas. A Universidade Federal do Paraná tem a honra de recebê-los, mesmo que virtualmente, para a solenidade de abertura do 14º Congresso de Direito do Autor e Interesse Público. O evento tem como objetivo discutir de maneira crítica e aprofundada o tema do direito da propriedade intelectual. Compõe a mesa desta solenidade de abertura o magnífico reitor da Universidade Federal do Paraná, professor Ricardo Marcelo Fonseca, o diretor do setor de Ciências Jurídicas da Universidade Federal do Paraná, professor Sérgio Said Stout Júnior, o coordenador do Congresso de Direito do Autor e Interesse Público, professor Marcos Vachovics. Agradecemos a participação dos servidores docentes, técnico-administrativos, pesquisadores, estudantes da UFPR e convidados. Neste momento, convidamos para fazer uso da palavra o coordenador do Congresso de Direito de Autor e Interesse Público, professor Marcos Vachovics.
Bom dia a todos e a todas. É uma satisfação estar aqui com todos, mesmo que virtualmente, para realizar o 14º Congresso de Direito de Autor e Interesse Público. Eu gostaria de saudar aqui a presença do magnífico reitor Ricardo Marcelo Fonseca, ao diretor da Faculdade de Direito, professor Sérgio Stout Júnior, bem como saudar a todos os nossos participantes e ouvintes e palestrantes que irão, nestes 4 dias, de 3 a 6 de novembro, trocar experiências, aprofundar temas ligados à propriedade intelectual, ao direito de autor e o interesse público. Neste ano, nós fazemos um evento totalmente virtual. E neste meio de pandemia, os esforços se somaram para que este congresso pudesse ocorrer. Eu gostaria de agradecer o apoio recebido pela Universidade Federal do Paraná e pela Unicuritiba, que possibilitaram também, novamente, essa parceria editada. Nesses 4 dias, nós teremos mais de 50 palestrantes internacionais e mais de 80 palestrantes brasileiros. Nós teremos uma mescla de pensamentos que vão somar com os trabalhos apresentados pelos pesquisadores, né? Teremos dentro desse nosso evento oficinas sobre plágio acadêmico, oficinas sobre recursos remotos, né? Porque nós, no meio de uma pandemia que estamos vivenciando, os professores estão sendo convocados numa nova modalidade de ensino que não é nem presencial e nem IAD, e os direitos que estes professores possuem com relação ao fazer em sala de aula virtual. Estudos de caso, teremos oportunidade de discutir o audiovisual e as novas questões relativas ao enfrentamento da pandemia com o streaming, rodas de conversa, e aqui teremos uma discussão sobre as artes em tempos de digitalização e como isso se torna mais acessível para toda a comunidade, destacando também minicursos, workshops dos grupos de pesquisa, que neste ano nós teremos mais de 65 painéis que englobam pesquisadores brasileiros e latino-americanos e europeus. Temos também a satisfação de, no 2º ano, realizar o concurso Apresente Sua Tese no CODAIP, o concurso em homenagem ao professor José de Oliveira Ascensão, onde tivemos também a oportunidade de ter teses e dissertações e trabalhos monográficos.
Senhoras e senhores, sejam todos bem-vindos e bem-vindas. A Universidade Federal do Paraná tem a honra de Senhoras e senhores, sejam todos bem-vindos e bem-vindas. A Universidade Federal do Paraná tem a honra de recebê-los, mesmo que virtualmente, para a solenidade de abertura do 14º Congresso de Direito do Autor e Interesse Público. O evento tem como objetivo discutir de maneira crítica e aprofundada o tema do direito da propriedade intelectual. Compõe a mesa desta solenidade de abertura o magnífico reitor da Universidade Federal do Paraná, professor Ricardo Marcelo Fonseca, o diretor do setor de Ciências Jurídicas da Universidade Federal do Paraná, professor Sérgio Said Stout Júnior, o coordenador do Congresso de Direito do Autor e Interesse Público, professor Marcos Vachovics. Agradecemos a participação dos servidores docentes, técnico-administrativos, pesquisadores, estudantes da UFPR e convidados. Neste momento, convidamos para fazer uso da palavra o coordenador do Congresso de Direito de Autor e Interesse Público, professor Marcos Vachovics.
Bom dia a todos e a todas. É uma satisfação estar aqui com todos, mesmo que virtualmente, para realizar o 14º Congresso de Direito de Autor e Interesse Público. Eu gostaria de saudar aqui a presença do magnífico reitor Ricardo Marcelo Fonseca, ao diretor da Faculdade de Direito, professor Sérgio Stout Júnior, bem como saudar a todos os nossos participantes e ouvintes e palestrantes que irão, nestes 4 dias, de 3 a 6 de novembro, trocar experiências, aprofundar temas ligados à propriedade intelectual, ao direito de autor e o interesse público. Neste ano, nós fazemos um evento totalmente virtual. E neste meio de pandemia, os esforços se somaram para que este congresso pudesse ocorrer. Eu gostaria de agradecer o apoio recebido pela Universidade Federal do Paraná e pela Curitiba, que possibilitaram também, novamente, essa parceria editada. Nesses 4 dias, nós teremos mais de 50 palestrantes internacionais e mais de 80 palestrantes brasileiros. Nós teremos uma mescla de pensamentos que vão somar com os trabalhos apresentados pelos pesquisadores, né? Teremos dentro desse nosso evento oficinas sobre plágio acadêmico, oficinas sobre recursos remotos, né? Porque nós, no meio de uma pandemia que estamos vivenciando, os professores estão sendo convocados numa nova modalidade de ensino que não é nem presencial e nem IAD, e os direitos que estes professores possuem com relação ao fazer em sala de aula virtual. Estudos de caso, teremos oportunidade de discutir o audiovisual, as novas questões relativas ao enfrentamento da pandemia com o streaming, rodas de conversa, e aqui teremos uma discussão sobre as artes em tempos de digitalização e como isso se torna mais acessível para toda a comunidade, destacando também minicursos, workshops dos grupos de pesquisa, que neste ano nós teremos mais de 65 painéis que englobam pesquisadores brasileiros e latino-americanos e europeus. Temos também a satisfação de, no 2º ano, realizar o concurso Apresente Sua Tese no CODAIP, o concurso em homenagem ao professor José de Oliveira Ascensão, onde tivemos também a oportunidade de ter teses e dissertações e trabalhos monográficos. E também, no final, teremos o lançamento das obras dos palestrantes. Este é o grande CODAIP virtual, este é o grande esforço que toda a nossa comunidade acadêmica conseguiu colocar para vocês. Serão realizados nesse evento questões relativas ao acesso ao conhecimento, questões relativas às novas tecnologias da informação e o uso delas no sentido de socializar o conhecimento, de difundir as obras autorais e a cultura. Eu agradeço novamente a todos que se inscreveram e que participam ativamente deste evento. Saúdo especialmente ao nosso magnífico reitor pela possibilidade de realizar o 14º CODAIP. Muito obrigado.
Convidamos para fazer uso da palavra o diretor do setor de Ciências Jurídicas da UFPR, professor Sérgio Said Stout Júnior.
Olá, bom dia a todos, bom dia a todas. É um prazer estar aqui, podendo abrir o 14º CODAIP online, na presença de dois queridos amigos e grandes professores, o professor Marcos Wachowski, coordenador do evento, e o nosso magnífico reitor da Universidade Federal do Paraná, também meu queridíssimo amigo e orientador, professor Ricardo Marcelo Fonseca. Quero dizer para vocês que, como anunciado, esse 14º CODAIP está, de fato, imperdível, né? Eu queria primeiro saudar a todos os professores, a todas as professoras, tanto os nossos participantes nacionais quanto os participantes internacionais que compõem, que participarão do 14º CODAIP. Gostaria também de cumprimentar a todas e todos os inscritos. Gostaria de cumprimentar também, né, de forma muito efusiva aqui, toda a equipe do GEDAI que participou e viabilizou esse evento. E, claro, gostaria de fazer um agradecimento especial ao nosso coordenador aqui, ao nosso maestro, professor Marcos Wachowski, que de forma incansável, mesmo com toda a dificuldade desse ano, monta um CODAIP que eu vou dizer para vocês, é o CODAIP talvez mais pujante, mais importante de todos esses CODAIPs, ainda que seja um CODAIP de forma virtual. O professor Marcos conseguiu utilizar aí, transformar essa situação, que é uma situação obviamente muito triste, muito ruim, né, numa forma de conseguir trazer inúmeros participantes. O professor Marcos me dizia, antes da gente começar a fazer essa abertura, que nós temos praticamente participantes de todos os continentes, com exceção da Antártida, né? Nós temos de todos os continentes, com exceção da Antártida. A gente vai investigar ainda se não tem alguém aqui da Antártida, né, nesse evento, mas temos aqui da Ásia, da Oceania, das Américas, da Europa, um evento de fato absolutamente imperdível. Como foi dito, mais, né, de 100 participantes, algo em torno de 50 participantes internacionais, mais de 70 participantes nacionais, palestrantes, né? Enfim, é uma honra, é uma satisfação, é uma felicidade para a Faculdade de Direito da Universidade Federal do Paraná e para a Universidade Federal receber um evento dessa importância. Arrisco a dizer que esse é o evento, nesse ano, mais importante do Brasil e, com toda certeza, também um dos eventos mais importantes do mundo inteiro na área dos direitos autorais e das propriedades intelectuais. Nesse ano, o Congresso se torna ainda mais importante justamente por conta da Covid, né? Muitas questões envolvendo tanto os direitos autorais quanto propriedades, especialmente a questão da propriedade industrial, serão discutidos nesse Congresso. Como os sistemas de direitos autorais, os sistemas de propriedades intelectuais podem favorecer e não dificultar o combate à pandemia, os tratamentos, enfim, me parece que são temas absolutamente centrais, bastante importantes. Queria, então, deixar o nosso registro, a nossa felicidade, de novo, aqui a nossa honra de estarmos aqui sediando, ainda que de forma virtual, esse evento. Eu desejo um excelente trabalho para todos os professores, para todas as professoras, para os pesquisadores, para as pesquisadoras, para os nossos alunos, para as nossas alunas, enfim, para todos os nossos convidados e participantes desse evento, desejando aí um excelente trabalho. Muito obrigado.
Agora, temos a honra de convidar o magnífico reitor da Universidade Federal do Paraná, professor Ricardo Marcelo Fonseca, para suas considerações finais e encerramento desta solenidade de abertura.
Bom dia a todos e todas. Uma grande satisfação estar aqui na abertura desse 14º CODAIP. Eu quero cumprimentar muito efusivamente meus dois amigos, o diretor da Faculdade de Direito, o professor Sérgio Said Stout Júnior, o querido Marcos Vachovics, que é o grande demiurgo desse gigantesco e importantíssimo evento, 14º CODAIP, ambos colegas do setor de ciências jurídicas. Eu quero, inicialmente, fazer esses efusivos parabéns à organização do evento, que, efetivamente, como já dito pelo Sérgio, se constitui, talvez, num dos grandes eventos jurídicos, e não só jurídicos, que se consolidaram ao longo do tempo. Vejam que nós estamos na 14ª edição. Uma 14ª edição que não foi sequer interrompida pela pandemia. E um evento com essa regularidade, sempre com o financiamento público e com essa capilaridade, mostra a pujança, certamente, não só do seu organizador, mas de todas as pessoas envolvidas, da sua comissão e, obviamente, da referência central da importância desse tema, que ano a ano é discutido nesse importante evento. Eu quero, portanto, o professor Marcos Vachovics, fazer esse registro de satisfação da nossa Universidade Federal do Paraná por hospedar mais uma vez e por, pessoalmente, eu estar mais uma vez, como tenho estado ao longo dos últimos anos, na abertura desse grande evento. Mas eu gostaria de fazer um acréscimo, registrando que o fato de precisamente estarmos encetando esses importantes debates aqui na Universidade Pública, nesse momento específico de pandemia, indica, como sempre tenho dito, a pujança, e não só a pujança, mas a centralidade, o caráter estratégico que a Universidade Pública Brasileira, como grande produtora de ciência, tecnologia e inovação no nosso país, tem ocupado particularmente nesses momentos. A pandemia certamente nos mostrou como a universidade, e particularmente a Universidade Pública, é central nas nossas vidas. Que sem universidade, tanto os avanços do ponto de vista biomédico, que agora tanto ansiamos, eles não acontecem efetivamente na nossa realidade, mas não só. Mesmo todos os efeitos que a pandemia acarreta em todos os âmbitos da nossa vida, em todos, eles são, sobretudo, debatidos, pensados e projetados por esse templo do conhecimento, que no caso brasileiro é a Universidade Pública. Nesse caso, especificamente, o professor Marcos Vachovics e esse 14º CODAIP demonstram a centralidade dessa discussão. Uma discussão onde direito de autor, direitos autorais, a possibilidade de livre circulação de informações, numa época em que boa parte do planeta está confinada e boa parte do planeta está ansiosa por informações seguras, por informações científicas, é algo que talvez tenha uma importância que nos 13 anteriores CODAIPs nós não tenhamos visto. De modo que, mais uma vez, portanto, a universidade, nesse caso emblematicamente, cumpre a sua função de difundir conhecimento, de produzir saberes com imensa centralidade e importância para a nossa sociedade. É um orgulho, portanto, a universidade, mais uma vez, contribuir dessa maneira e especificamente nesse debate, professor Marcos, que, repito, tanto nos orgulha na universidade e é tão central na sociedade. Eu quero cumprimentar cada um e cada uma dos participantes, os mais de 50 convidados estrangeiros que vêm de 5 continentes. Quero cumprimentar os mais de 1000 participantes desse evento online, toda a comissão organizadora, todos os professores brasileiros, mas mais uma vez deixar o meu abraço ao querido Sérgio Stout Júnior, o diretor da faculdade, e ao Marcos Vachovics, o organizador desse evento, desejando que do dia 3 a 6 de novembro todos tenham um excelente congresso. Muito obrigado.
Senhoras e senhores, com o encerramento desta solenidade, desfaz-se a mesa de abertura. Convidamos a todos e todas para a continuação do evento. A programação completa está no site gedai.com.br. A Universidade Federal do Paraná agradece a participação e deseja um excelente seminário.
to present his speech on cut and paste, plagiarism and self-plagiarism at the crossroad of copyright and ethics. François de Semonte is professor at Lausanne University, if I don't say it wrong, and he's also a WIPO in WIPO. His speech on cut and paste, plagiarism and self-plagiarism.
Do you hear me well? Hello. Do you hear me well?
Yes, I can hear you.
That's good. So I go on with my speech, and I first would like to thank very much the organizers to have invited me to talk today and to accommodate my schedule. Today in Switzerland it's especially gray and dark, and so I'm happy to think you are in a sometimes sunny country and not as rainy as ours anyway at this season. I would also like to thank very much
I'm sorry.
Today in Switzerland it's especially gray and dark, and so I'm happy to think. Yes, can I go on? I would like to thank very much Lucas and Pedro for their help. I thought it would be a very successful help with the technical side of that transmission. But do you hear me? Can I go on? I would like to thank very much Lucas and Pedro for their help. I thought it would be a very successful help with the technical side of that transmission. But did you hear me?
I really don't know what's happening, but it's a little messy. I'm hearing 2 or 3 voices at the same time. Do you see?
I suppose one voice, mine, would be enough. But if somebody wants to take over, I'm leaving my place as soon as you tell me. But if you want me to go on, I'm afraid we have a problem due to the long distance between us. Is that the case? That you hear like an echo of my voice? Hello? So I'll try to go with my text, and please stop me if you don't hear me. My questions are actually on 2 sides. The first side is how much can an author cut and paste from a text written by a different author? That may be plagiarism or a loud quotation. And my second question is how much can an author cut and paste from his own previous text, especially when his first text has been published. We talk here of self-plagiarism. I'm of course talking only about cut and paste of texts. I'm not talking about different cutting and pasting of photographs or images, for example, in artistic collage, or the most difficult question surrounding the use of pre-existing music. I'm not going into those different questions. I'm just going into the cut and paste of text. For text, the plagiarism is a well-known phenomenon. Let's give some example. 2 German ministers have held position in the German federal government until So those two ministers had to withdraw in 2011 and 2013 for having plagiarized important parts of their PhD thesis. Another person, important political personality, Mr. Schmidt, president of the Hungarian parliament, had to withdraw for the same reason. He had plagiarized most of his PhD thesis. In my own country, Switzerland, Professor Bruno Frey, emeritus at the University of Zurich, had to stop giving classes in 2012 after it had been discovered that he and 3 co-authors published 4 times the same article on the Titanic shipwreck. That's an egregious case of self-plagiarism. But there are so many more examples that in Coimbra, 30th October and 31st October 2020, a World Convention has been held for academic ethics and also these questions of plagiarism at the university. About 300 cases have been reported. I shall first focus on plagiarism, and then I'll focus on self-plagiarism. The definition of plagiarism is simple. The plagiarism assumes the presence of one objective element, that is, borrowing somebody else's text. Besides, there must be 2 subjective moments, that is, the awareness to copy and the intention to pass off the text for one's own writing. Following cut and paste, the objective element is always present. The first text is obviously borrowed, but through the cut and paste method. The subjective element, the awareness to copy, is usually present to the extent that the author sits behind the screen and is therefore aware to copy. The second subjective test, that is the intention to pass off as one's own somebody else's work, is not necessarily present. If the name of the author is cited in the quotation, then it may be admitted under the exception to plagiarism called the right of quotation, or in Europe, the right of citation. In practice, either you have plagiarism when you cut and paste, or you have an access to the right of citation. You have the exception to copyright, and you can invoke it. About the length of the quotation, we'll come back later. But then, what is plagiarism really? Interestingly, it comes from the Latin ad plagas. Under the Roman act Fabia de Plagiaris, an action could be filed against any person who bought, sold, or kept as a slave another free person. Under the Lex Flavia, this usurpator who wanted to pass off as belonging to him children or adults who in fact did not belong to him should be sentenced to whipping, in Latin ad plagas. Of course, the Roman law did not know intellectual property proper, but it gave us the word plagiarism. It has not been looked down upon before the 18th century, I believe. For example, it is said that Shakespeare wrote only about 1/3 of all the 6,000 verses of Richard III. Montaigne, the great French essayist, copied Plutarch. Jean de La Fontaine copied and adapted Aesopus, and so on and so forth. It's only at the end of the 18th century that Voltaire, very unhappy about the theft of his ideas, characterized plagiarism as larceny. And this led to the situation under copyright law. In France, the first litigation for plagiarism dates back to 1842. It opposed the publisher of a newspaper, La Presse, to an author, Maurice Cousin, who had contracted to deliver installment for a serial publication. But this author, Maurice Cousin, had in fact copied a novel published 30 years before, in 1802. So this story shows that ease of copying to make oneself more well-known in the press and to get the monetary rewards of authorships came as early as the early 19th century. Later, in France as elsewhere, there were many cases about plagiarism. For example, in the 20th century, Jacques Attali, Alain Mick, Patrick Poivre d'Arbour, Alain Perfit, and other well-known names of the French literary circles have all been attacked for plagiarism. Now, what was the situation in the French copyright law? For a long time, it was thought that it's not plagiarism when you don't take literally all the words of the other author. In order to be a wrongdoing, plagiarism has to be characterized as counterfeiting, that is really copying a good part of the author, and of course, it has to escape the exception concerning the right of citation. But if you just copy, for example, the plot of an author, this is not plagiarism. Perhaps some of you will remember La Bicyclette Bleue. That's a novel by Régine Desforges, who was alleged to be a plagiarist of Margaret Mitchell, Gone with the Wind. In fact, Régine Desforges won her case because it was a translation. It was not cut and paste. And you see here how generous the French courts were towards French authors. But the wind is turning. In the 21st century, we have another view. In the 9th edition of the Dictionnaire juridique Capitan of 2011, plagiarism is defined as the wrongful misappropriation of somebody else's work in all or in part. And the emphasis here is on wrongful. The standard treatise on copyright in France, the one of my friend Lucas, clearly states that even if ideas can be re-expressed, any copying of the words, especially through cut and paste, is wrongful. If I turn now to Swiss and German law, there has never been such tolerance for plagiarism as has existed in France for a long time. For Swiss commentators, for example, as soon as full sentences are copied, either the right of citation covers the quotation from the former text, or it does not. So the test is the right of citation applicable? And we now turn to the right of citation. In our law, 1992 law, revised in 2019, the right of citation is embedded in Article 25 of the law. Article 25 protects the free discussion of ideas by balancing the moral rights of the author with the public interest to an open examination of the opinion that were formerly held. Article 25 of copyright law in Switzerland does not take into consideration the rights of the publishers. It will protect only the moral rights of the author, not to be stolen, the paternity of his ideas. If the commentary focuses on the moral rights, this is due to the requirement to cite the name of the author in order for the quotation to be allowed under Article 25 Swiss Copyright Act. Now, in the case of cut and paste, it's exceptional that the name of the author of the first text be mentioned, or the source indicated if his name is not known. Why? Well, the plagiarism aims at boasting that one has found good ideas or new expressions. From the point of view of the pirated author, plagiarism is theft. From the point of view of the plagiarist, it's a rather enhancement of fortune and fame. if there is a citation with the name of the first author, then there will be no enhancement of the second author, fortune and fate. The question which is most difficult is here the length of the quotation. It depends very much on which text we are talking, and I recall we are talking only about texts here, not about pictures. Usually the quotation, however large, will not affect the sale or other exploitation of the original work when it is a text. So it is even possible under Swiss law to quote the full text, say for example of a poetry, if we want to analyze the style and characteristics of the poetry. In the US, the question of the length of the quotation under the fair use exemption has received varying answers. For example, the US Supreme Court, in the case Harper versus Nation Enterprises, a case of 1985, has decided that borrowing 300 words out of 200,000 words of the memoir by former President Gerald Ford was not a fair use. It was too much, 300 words out of 200,000. But courts are sometimes more lax. And for example, the Southern District Court of New York, the court for the Southern District of New York, the federal court, in the case Rothbard, said that it was possible to copy 800 words out of 14,000. There is here a difference to be made between literary text, or the text that most of the students and pupils would cut and copy and paste in our universities on one hand, and scientific texts that are published in scientific journals. Professor Laure Marino of the University of Strasbourg in France has proposed to evade the rule limiting the length of quotation in the area of scientific research. It would be to allow researchers to freely quote the published research of their antecedent. So cut and paste could go very far. The economic and scientific literature should be seen as a common good belonging to mankind as a whole. And I would recall you here two fundamental freedoms. First is Article 13 of European Convention on Human Rights, which reinforces the freedom of the arts and sciences. And this can be in conflict with copyright law. And there is a second freedom, Article 10 of the European Convention on Human Rights, that protects the freedom of expression. But here we should also take into account the latest movement of the case law in Europe. And most of you are certainly aware of the case of the European Court of Justice in the matter Metal of Metal. That's a decision of 29 July 2019. It was about the possibility to make techno music. Can you cut and paste some element of a prior published song? This case, the decision of the European Court of Justice, to negate the right to free expression, and the German Supreme Court, Bundesgerichtshof, in its decision of 30 April 2020, that's 6 months ago, decided that there was no longer the right to free use that has been ensconced under the German copyright law and taken by case law in some other countries like Switzerland. So we see that there is no right to free use. And therefore, I think that the basis of the reasoning of Professor Laure Marino, that we should open, actually cut and paste to all scientific literature, there is no base for this opinion under Article 10 or Article 13 of the European Convention on Human Rights. Of course, I see what she wanted to say. Look at with the COVID pandemic we have now. Should copyright impede the flow of publications? I think, yes, I think publications are rather in excess and their quality is not always checked as it should be. Some of you may be aware of the problem that a big scientific publisher, Elsevier, had some years ago, because it was found that they added cross-references to the publications of their authors, so as to get for their articles a better ranking in the numerous comparison you have between universities and publishers and authors. It was not extremely fair, I'd say, as a trade practice. And so we cannot rely on the simple fact that a review is peer-reviewed to make sure that there is no cut and paste. I think we should really prohibit cut and paste. And if we cannot prohibit it under copyright law, as it may be difficult in some countries, at least we should be prohibiting under deontology. There is one, and I'm coming to deontology in one moment, but there is one last observation I'd like to make in this sense for plagiarism. It's that a long quotation might be admissible if the new text is somehow transforming the pre-existing state of knowledge. For example, in the case on parody, Akufrose versus Campbell, the famous case of 1994 by the US Supreme Court, the transformative effect of taking some elements of the prior publication, the song in that case, has been decided as a decisive test. And in the famous case, Oracle versus Google, concerning the application that have all our telephone working, it's exactly the same. It's transformative effect of the Android application big enough, large enough, important enough to justify the cut and case, cut and copy, so to say, of the program. You know that this case, the Supreme Court has heard the parties, I believe, on the beginning of this month, I believe the 4th or 6th October, and the decision will be given under the new composition of the US Supreme Court in this present term or later. Now let's turn for just a few words on deontology. For all practical purpose, it can be said that any act that is wrongful under copyright law is contrary to academic deontology, but the reverse tenet is not true. Some acts that are acceptable under copyright law may prove to be contrary to academical ethics, as we are now going to see. And I turn to the next and last topic, self-plagiarism. What is the definition of self-plagiarism? It has been born in the USA in, I believe, the article of Pamela Samuelson, my dear friend of Berkeley University. The article is 1994. And she said basically, if the author of a text reused the same 2 pages in a subsequent article, it is almost inconceivable that copyright infringement could be found, even if the author had assigned a copyright in the article to the first journal. So self-plagiarism means this cut and paste from your own article. It's perhaps a misnomer. Everybody talks about self-plagiarism, but really plagiarism is a false claim to be the author of a text somebody else has written. If you allow me, it's a raven picking up the feathers of a peacock to adorn himself. In self-plagiarism, it's different. The self-plagiarist just boasts of his creativity. He says, look, I publish more than I write. he's like the frog who tries to pass off for an oxen. He's taking into his own publication prior publication he has made. He's not making a creative effort, a fresh new start each time. He's copying himself. Now, Professor Samuelson mentioned that even if the author has assigned the copyright in the article to the first journal, then there would be no wrongful act under copyright law. This we could discuss more at length. A possible reason to see a conflict between copyright and self-plagiarism lays with the publishing contract. When the contract prevents the author to republish his article in a different review, the self-plagiarism may be in breach of his contract. If the self-quotation is extensive and no indication of source is mentioned, the copyright pertaining to the publisher by virtue of the assignment may be infringed. But this will depend on which law is applicable. As you know, under the US approach to copyright, the assignment may vest the publishing house with the entire copyright. There is no more right coming into play. For example, when the publisher has given to the author the support and assistance of a whole team researching topic, when the publisher then edited the author's first text, the publisher has an exclusive right, and the author might commit a wrong if the author is republishing the very same text through cut and paste without the approval of the publisher. Under European law, the traditional view is that the publisher gets the right to publish exclusively or not for the first edition or for several ones. There may be a breach of contract if self-plagiarism runs counter to the exclusivity of the first publisher in time. The outcome of possible action by the publisher against the author copying himself will depend on the harm that has been inflicted or not to the publisher. I've seen a few cases, and in most cases, I may tell you, the harm will be impossible to prove. And just to make it a bit lighter, one of the most funny cases I've seen was one on a book on recipes, where an author had taken for the Swiss edition about 2/3 of a book published in Germany. You know, we have the same length. So, same language. So, of course, if you publish 2 texts, then 2 times the same text without telling the second publisher, this is not correct. As to the copyright infringement, I think there is no copyright infringement in Switzerland. And I would say that the author of a text remains in possession of the right to adapt his work, and if so chooses, is free to reinsert part of all in a new work. So in my view, most of the case, and with the exception I've mentioned of the publisher giving full support to an author and so on, self-plagiarism does not raise many problems under copyright and contract law. But what about ethics? And here I'm just going into some case studies. Let's turn to the cut and paste of a text with automatic translation into a different language. Only very special circumstances might hinder the second publication. Usually, when I make an article for a Festschrift, a Liber Amicorum, the Liber Amicorum is for my friends, and for the use of my friend I want to honor. So I want to give him an exclusivity of sort to my friend. Sometimes it's him, sometimes it's her I give an exclusivity to. Sometimes I've been asked for republication in a well-known international legal journal, but it was my view that as I gave my article to my friend, it shouldn't be republished elsewhere, even if it would have given much more audience to my poor thoughts. This is, in my view, a personal tenet, and I know that some editors of international legal journals have been surprised that I don't give away the right to publish. On the other hand, if I wanted to do it, I think it would be correct to do it, cut and paste, have a program translating it, or possibly a translator, and then to mention the first publication. I turn to the second publication at the request of a different journal, but in the same language. We have all made this experience. The journals from different continents, when they see one of our articles in English, French, Spanish, or Italian, or German, want to republish it in their own area, in the language they have usually for their publication. It's sometimes a translation, but very often it's just a publication as is. Then there is a cut and paste of the whole article, and the editors of the journal come to you and say, okay, I've prepared everything, do you agree now? It's very difficult to say no, and with the authorization of the first publication, I think it's possible to accept this self-plagiarism only with mention of the first publication. Let's turn to a third case, the replication of part of an article in different publication. This is a more complicated story, and I try to make a hypothetical so everybody understands. You know that Mrs. Elinor Olson got the Nobel Prize for Economy in 2009 for her theory about the governance of the commons, something which is important for copyright. She could have expressed her basic principles about the management of the commons in a set of concise formulas or pertinent sentences. It would be the first publication. Then in the following years, she might have applied those very same formulas and expressions to different of management of commons. Each time there would be a general part with introduction and cut and paste from the original publication, then the special part would be original, applying it to different commons. Would that be ethical? The question, as far as I see, has not been addressed in the copyright literature anyway. I've seen 2 or 3 non-lawyers saying 2 or 3 interesting things that are not based in law at all. And so I'm not going to cite them. My own view is that the originality of the author's thoughts is decisive. The transformative test of Acuff-Rose versus Campbell, the US Supreme Court case of 1994, is applicable to wherever the general part embodying the main achievement of the writer research is highly well expressed and individual, this writer is entitled to cut it and paste it in front of further case studies exemplifying the theory. I am finishing with the multiple publications before candidacy to an academic position. Some of you have, of course, sat on committees selecting new professors. It has happened that somebody has applied and given 11 different articles had written. And when one of the members of the committee was kind enough to check, he saw that the 11 articles were identical to each other or quasi-identical to each other. That's, of course, not acceptable. He thought probably the members of the committee, who are, of course, full-tenured professors, are so overwhelmed by their administrative duties and other activities that they wouldn't look at 11 articles, but they did. So the multiple publication runs afoul of the most academic requirements. For example, in our law school, a PhD thesis has to be both individual and original. This precludes giving as a PhD thesis something that has been partly published, for example, as an article of a journal before. And now, on the request of my president, I'm going as chairman of this session, Professor Frontera. Thank you to have given me those few minutes. I'm going to conclude. I'm going to conclude talking about fairness and ethics and about development of the law. I think in plagiarism and self-plagiarism, there is a violation of good faith. I think that when it happens to the university, it's contrary to fairness and ethics, and it has an effect on the academic market. And when we have an effect on the academic market, what do we have? We have basically a case of unfair competition law. This may surprise you, because some countries don't apply unfair competition law to activities like scholarly activities, publication in journals or research, or even what the students do at school. They think that they have a narrow notion of economic market and economic activities. We in Switzerland, like in Germany, on the other hand, we have a large notion of what are economic activities. I think when we think of, for example, the young man who is writing 11 times the same article, publishing it in different journals, just to bloat himself like a frog who wants to be an oxen. This young scholar is actually having an unfair practice. It includes a misleading statement about his or her capacity to write, to make research, and to publish interesting things. So it should be possible to have at least a declaratory judgment about unfairness of his or her practice. I think, of course, only egregious cases of intellectual dishonesty should be pursued under the law, under unfair competition law in particular. And I think this is a new theory. It will take some time to be applied. But let's see, the very problem is not really which sort of law you apply. The very problem is, do you have a register for saying, for mentioning that there has been an offender against ethics in the academic world? As long as we don't have centralized registers about the past sin of professors, PhD doctors, and so on, as long as we don't centralize this information, the remedies under law, under copyright law or unfair competition law, the remedies under deontology will be few and perhaps useless. Thank you for your patience. I'm stopping now.
Merci beaucoup, professeur François de Semonté. Je suis enchanté de votre excellente présentation. Thank you very much, Professor de Semonté. I liked very much your excellent presentation. I would like to keep this session going on and ask Professor Sean Flynn to make his presentation on the right to research. Thank you very much.
Thank you very much. It's a pleasure to be here. There, okay. I will take over the screen in just a moment. But I just wanted to say it's a distinct pleasure to be here again and address this really incredible audience that's been brought together to speak about these issues for so many years. And a huge disappointment that we can't do this in person. I'm going to miss the beers late at night and on the dark alleys in Curitiba. So all of you who participate in those activities, I hope we can do it in spirit in any case. So let me turn over and share my presentation. There, okay. Let me also thank Jose. It's great to see you again. I think you must be the best English speaker in the patch because I think you always get the hardship assignment of moderating the English speaking group among us. So thank you for your perseverance. And let me thank Marcos again. This is always such a fabulous group of the speakers from all over the world. And of course, the best students from all over Brazil always come together at this conference. So today I want to describe some of the new research that my group at PIGIP at American University, Washington College of Law, has been doing with respect to the right to research and its intersection with copyright law. But I know that it seems everybody in the world is cognizant that today is an election day here, and I'm sitting in Washington, D.C., the belly of the beast. And so you probably want to know exactly what's going on. And all I can give you is my prediction, which is that when we are finished counting all of the votes, which may take some time to get there, I will personally guarantee you that the Democrats will control the DC City Council. So that much I can tell you for sure. The rest is a little bit hard to figure out at this point. So I'll just have to quote one fearless leader that you all know and say, we'll see what happens. So now to more important news. You know, there are things more important than the US election, although it doesn't always feel like that. But one of them, of course, is battling the coronavirus pandemic that's ravaging the world and keeping us from being productive and seeing each other. And that's a good entry point into the theme today, which is how to rectify our needs for research and our rights to both do and receive that research with the copyright system. So I don't know how many of you know this, but the coronavirus epidemic, the COVID pandemic, was discovered not by a person, but by a machine. It was an artificial intelligence company called Blue Dot that exists in Canada that first discovered weeks before the WHO the emerging health crisis in Wuhan, China, and advised its clients to halt travel to that region. And it did so by digesting massive amounts of copyrighted material into a database and searching that material with an artificial intelligence engine. And it compared that material, which came from, for instance, news reports, which are copyrighted in every country, government reports, which are unfortunately still copyrighted in many countries, from all around the world, compared them with flight logs and travel statistics, some of which may be under copyright, some of which may not be, and used that to find correlations between health outbreaks and travel statistics and identified the spread of this virus from Wuhan, China. So it was an artificial intelligence company. It was text and data mining research that first found the coronavirus and led to some of our efforts to combat it. And there's also text and data mining research being done by health researchers, for instance, that digest hundreds of thousands, perhaps millions of scientific articles into databases and search for correlations using text and data mining and artificial intelligence techniques to try to find cures. And text and data mining researchers, artificial intelligence, are also combating the other huge problem that has come to the surface today around racial justice. So studying hate speech on social media, for instance, there are researchers copying massive amounts of copyright protected social media texts and content and searching that content for various kinds of both political misinformation and different kinds of hate speech to be studied and monitored. So all of these and many other massive issues that we have going on today is being studied by researchers, both commercial, Blue Dot was actually a commercial researcher, and non-commercial researchers seeking to make our lives a better place. So that's the entry point into this discussion of how we rectify those rights to research, which sound in human rights guarantees. Article 19 of the Universal Declaration protects not only freedom of mind, but the right to seek and receive and impart information. In short, it protects a right to research, to both do research and to receive the outputs of research. And that lies in some tension with our primary means of incentivizing the publication of such research, copyright. So Article 9 of the Berne Convention, for instance, states that all countries must give authors, in the first instance, ultimately publishers to which those rights are assigned to, the exclusive right of authorizing the reproduction of those works. How do you receive and impart information without reproduction? And as I've told you in the text and data mining and artificial intelligence introduction, it's literally impossible to use those tools without technically reproducing items that are copyright protected. So I want to progress with this talk in 3 parts. And the first and longest part is to show you some research that we are doing mapping how copyright laws protect rights of research within their exceptions. And then the second part is to show you a little bit of the research that we're doing showing the impact of different formulations of those exceptions on research itself. And then I'll conclude with some policy ideas. What should we take away from these different kinds of research on research, if you will, towards the construction of both national and international copyright law. And again, that'll probably be the shortest part of the talk today, but let me shift over to the mapping exercise. So this is new, but is an extension of research that I've presented at this conference before. So the user rights database, and I'll talk a little bit more about that in the second part. This is in some degrees an extension of that user rights database mapping of exceptions that exist in various places. And so the first part of this mapping is looking at the research environment in the United States and Canada, right? So that the Blue Dot AI company is based in Canada, not the United States. It's often thought that the United States has the most hospitable exceptions environment for text and data mining research and artificial intelligence, et cetera. And we actually conclude in our research that at least on this matrix, when looking at research purposes, Canada and the United States are functionally equivalent. The difference between those two systems is on the purpose axes of the exceptions. So one of the categories that exceptions differ between countries is on the purposes that they permit works to be used for. And the distinction between the United States and Canada, the most meaningful distinction, is the words such as in the United States Fair Use Clause. So fair use doesn't have a purpose trigger. For all intents and purposes, you can go straight to the fairness factors, and they're articulated here, unlike in Canada, but I can tell you the Canadian courts apply essentially the same 4. They technically sometimes articulate 5 factors in deciding what's fair in Canada, but they're functionally equivalent. They focus most expressly on 2 main factors. The type of the use, is it transformative? Does it serve a different audience for a different purpose than the original? And the market test, is it displacing a market? Is it substituting for the original in the markets in which that original serves? And so text and data mining research, as was decided in the Google Books case and the Hathi Trust case in the US, and similar but not exactly on point cases in Canada, have essentially said that this kind of copying, the reproduction of works into a database for the purpose of creating new information from those works, is both a transformative purpose and one that does not substitute in any markets. And so in our research, we are, as I mentioned, evaluating them as equal. They're both green in our model, green for go for data mining. These are both exceptions, despite their differences on the purpose restriction. Both of them adequately cover the use of, for instance, whole works under appropriate means by any user in appropriate circumstances for any kind of research purpose, commercial or non-commercial. And there's cases in both Canada and the United States that say commerciality does not restrict you, does not ban you from using the exception. And so for our purposes, again, functionally equivalent. I just wanted to point out that the functionally equivalent, the kind of green for go TDM exceptions are not restricted, as is sometimes thought, to Commonwealth countries. You don't have to have derived your legal system from the UK base in order to have an open research exception. So Indonesia is a good example. All of the same criteria are protected in Indonesia as in Canada or the United States. They're, at least as far as research purposes go. Sorry, flipping to Indonesia now. So in Indonesia, at least as far as a research purpose goes, you can use a work. So it's not restricted to reproduction. It's all different types of uses. And why is that important? Well, one reason it's important is because researchers doing text and data mining research need to not only create reproductions to create the database, but often need to share works between each other. So if you think of collaborative research projects that would be done between researchers in different institutions and possibly different countries, they may need to share works with each other for the purpose of research. So they need a communication or a distribution right. The validation of text and data mining tools and the databases on which they draw require sharing those databases, including the full underlying works, with others for the purpose of validating those tools. So all of those can be roped into that definition of use. So fair use, or in Canada, fair dealing. A dealing is just a fancy word for a use. All of those apply to all the different rights protected within the copyright system. And here it applies to a research purpose, and it really turns on, instead of a 4-factor test, mainly here just a 1-factor test, but without harming the reasonable interests of the author. So it enables the cabining function to come into the balancing test instead of the trigger on what kind of a purpose is being used. So all those in our map, we label green. So next topic. Shifting colors represents that we've shifted categories. So there's something different about the recent 2019 EU Digital Single Market Directive, which explicitly protects text and data mining activities, but it doesn't protect all of the rights. It doesn't use a broad term like dealing or use or utilization. Instead, it only extends to the rights to reproduce and extract material. So it only extends to the creation of databases. It doesn't extend to the sharing of databases or the sharing of materials in order to create those databases. And here, the EU actually has 2 different articles. This is Article 4, which applies to all different kinds of users. So it's open on the subject of which users can use it. But then if you're relying on Article 4, you have to comply with Article 4.3, which says you have to give content holders an opt-out. You can only use material that has not been, that the use for which has not been expressly reserved by rights holders. I'm not sure exactly how that's going to be implemented in fact, but essentially kind of like website owners can have a do not crawl message in their coding on the back end of the website, you could have a do not research warning that would prevent at least commercial users from using that material. And I mentioned there was 2, and here's the second, Article 3. Article 3 is different in the 3rd paragraph, you'll see. So for non-commercial users, and in fact, they don't use the term non-commercial, they use research by research organizations and cultural heritage organizations. So those type of organizations may research items even if they have those do not crawl commands. So they can research a broader scope of works. But in order to take advantage to that broader use right, covering a broader scope of works, you have to be a certain kind of an institution. So that's what purple means in our matrix. So we have green. Green is you can have both reproduction and sharing rights, very broad. Blue, only reproduction, no sharing. Purple, the rights go to an institution instead of an individual. And then light blue, the rights go to an individual, not an institution. So here, Azerbaijan is an example of a research right being encoded into and restricted by the personal use right, the private use right. So it's a right of an individual. It's not a right of a research organization. Often these rights state explicitly that the use must be for a non-profit or non-commercial purpose. And other times we would probably imply that restriction, even if it didn't exist, into the very definition of a personal use. So we code these blue because they're reproduction, not sharing rights, but distinguish them. We code them light blue because they encapsulate within them a restriction on the individual and a restriction on the commercial, non-commercial purpose for which they may be used. New category, yellow. So here, what's the difference? You still have free reproduction. It's limited to personal uses, but here we have an exception. So fairly common among personal use rights is, in addition to saying that that use must be nonprofit and must be an individual right, it also excludes a category of works, whole books. So I mentioned at the outset, the Google Books case in the United States is an example where there was a fair use right of a commercial entity to make copies of whole books, indeed whole libraries, in order to create a new research tool that does not express those works itself, but express outcomes of research, of searches that you can do on Google Books. So you can word search entire books, come up with excerpts, quotes, or citations, in the words of the last presentation. And you may extend that to entire books. But if you're in a yellow country, that right does not extend to whole books. So there can be no Google Books product in Russia, which is pretty interesting to think about, because there must be a huge amount of Russian language texts that probably only exist in Russia. There's just a few countries outside Russia that would speak that same language and undoubtedly do not have the same size library. So no Russian language Google Books can be created under this current environment. And finally, red, as you've probably figured out the color scheme, it goes from green, the most permissive, to red, the most restrictive. So here I've underlined 5 different kinds of restrictions. First, it applies to a person, not an institution. It applies only to the act of publishing. It doesn't even cover reproduction explicitly. The purposes are limited to scientific and didactic purposes, a subset of research itself. The works themselves must be intellectual works, not all kinds of works. So query whether social media accounts fit, whether fiction fits, whether pure entertainment programming on broadcast fits that definition. And fifth, it has an exact restriction. You can only use up to 1,000 words. So no whole books, not even whole articles. So these ones are red for data mining. Under a provision that's so restrictive, especially that is restricted to the use of only extracts, essentially you can't do text and data mining research at all. Because in order to do that kind of research, you need to make whole copies of whole works into a database to search it. You can't pick out 1,000 words to put in your database because you don't know which 1,000 to put in before you've done the research. So Argentina, essentially a blockade on text and data mining research. And the upshot is Brazil, at least on the face of its statute, is similarly restrictive. Its research exception, to the extent it has one in Article 56, is limited to reproduction. It's not quite as narrow as Argentina. It's not limited only to publication, only in a single copy, only of short extracts, only for the private use of the copyist. So, and expressly defines within that a non-commercial use. So Brazil, like Argentina, it's essentially a red light. You may not do text and data mining research. And I'll drop the footnote here in that I started out with the fundamental rights guarantee that may conflict with copyright law. And I know from the research of Alan Rocha and others that actually the Brazilian courts are starting to apply fundamental rights to open up exceptions to copyright, even where the face of the statute does not permit it. And so this may be one of the areas where such fundamental rights litigation is needed within Brazil, if it does not amend its copyright law, in order to enable the kind of information producing, research facilitating, truth enabling research that text and data mining, machine learning activities can help. So with that diagram, so we've had 5 different colors. We've talked about restrictions on purpose, restrictions on types of works, restrictions on types of users, restrictions on the amount that may be copied. We're ready to show you the map of the world. So we've analyzed almost all the countries in the world under these rubrics. We don't have, unfortunately, the law of Greenland, especially unfortunate because it's such a big country on the map. So the gray countries are the ones that we don't have copies for. If you look very closely, you might be able to see Iraq, Syria, North Korea are countries that we don't have the laws for. But the rest of the countries, we were able to find and translate copies of their research exceptions and code them on the different factors that I presented to you. So the green countries, recall, are those countries in which you can both share and reproduce materials. The blue countries, both light and dark blue, you can reproduce but not share, but the right countries exist only in a private use exception, which means you'd have to read in a non-commercial use into that exception. And it's only a person, not an institution, that can do the copy. The few purple countries on this map are countries that have no personal use, no individual right to do that research. The right is only an institutional right. The yellow countries prohibit the use of full books. And the red countries, clustered in South and Central America, are the countries that only have on their face exceptions for uses of excerpts. They don't allow the full use at all. So again, that brings to the front the potential conflict between especially those laws and fundamental rights guarantees that protect our right to both receive and impart information. So fertile grounds for human rights lawyers to help us solve that case. So I mentioned that I would say a few words, and I'm going to go a little quicker over these 2 parts, but on the potential impact. So of course, one impact is you enable the kind of research that we've been talking about. Another comes from our research on the user rights database that I mentioned at the outset. And I've showed this slide before, but just to, in this environment, but just to remind you perhaps, if you've seen me present this work in the past, that the result of our user rights database is to show that countries in general are moving towards more open exceptions over time. So this is a graph looking at a basket of 40 countries, half of which are wealthy countries and half of which are middle income countries, looking at how open all of their different rights are, including research, along the different elements we've discussed, on whether they're open to the full range of purposes, full range of works, full range of users, and full range of protected uses. And as all of us are amending our laws over time, we tend to be moving towards the more open direction, but the wealthy countries are moving faster than the poorer ones. And so the gap between the two countries charted in this chart is widening over time. It's a direct contradiction to the theme we often hear from Northern rights holders that the poorer countries, the developing countries, are free riding on the works of the North. Actually, it's exactly the opposite. The wealthier countries tend to have much more permissive exceptions, and the poorer countries tend to have much more restrictive exceptions on all of those axes, restricting by purposes, restricting by works, restricting by users, restricting in the rights that they give authors. And so what's the impact of widening those exceptions over time? We've just done some of that analysis, and the impact is perhaps, as you'd expect, countries that allow more research uses actually produce more research. And so what do we take away from that? So domestically, you could change Brazil green by opening its research clause to include all kinds of research uses that do not compete with the rights of the author. Internationally, we could change the international treaty environment, and perhaps the lowest hanging fruit would be to take the lesson we learned from Marrakesh and to say that countries can share works with others as long as they were lawfully created in that own country. If we extended just that simple rule, you can share lawfully made materials. Then when you looked at this map and thought about where you were situating in the middle of a red country in Brazil, the answer would be you could collaborate across borders. You could collaborate with researchers in any of the green and even the blue areas and be able to at least use and share and exchange information between those countries and be part of an ultimately a collaborative, international text and data mining project. But to produce those projects yourself in your own country, you need to amend your own law or achieve the kind of perhaps fundamental rights litigation we've talked about that really begins to elaborate the space in between the international rights to research and our international copyright and national copyright systems. So I will leave us with that and give it back to Professor Jose.
Thank you, Sean, very much for your very instructive and interesting presentation. As always, I like very much to see the angles you put in these very important questions. And I sincerely hope that Brazil changes its ways to treat the use of copyright to research. Thank you very much. I would like to ask Yogesh Pai to start his presentation about educational exception to copyright law in India and the post-COVID-19 scenario. Thank you, Yogesh. Please take the stand.
Thank you very much. I thank the organizers, Professor Marcus and others, and especially the chair today for helping put up this panel. It's been a wonderful session so far. We have two great experts on copyright law from two different continents, and here is a view from India on what is happening on the educational front. So The topic that I chose to pick up was the educational exception, because it has so far been litigated in India in the pre-COVID scenario, primarily in relation to course facts and materials. But in the post-COVID scenario, this might have or need a radical change. So the brief overview of what I'm going to talk about in the context of educational exception is first to look into the nature and limits of the discourse on education itself, and what does it mean to have an exception to copyright in the form of an educational exception. And this is more so in the light of whether you can really have a public good such as education as carved into an exception, or do we need something more than that? Then we'll try and look into what is the post-COVID scenario in terms of education itself and what has changed forever. And we'll look into a question of digital libraries and what kind of uses in the online environment are anticipated, and whether those are prospectively covered by India's law. We'll look into the nature of the law itself, the exception in the Indian, what we call as fair dealing. Unlike in the US, in case of the US, it's a fair use exception, though you have two-factor test. But in India, you have a list of exhaustive provisions. Being the common law country, we were one to follow most of the common law countries in terms of having a long, exhaustive list of exceptions. Then we will look into the digital lending and doctrine, and whether digital libraries can actually lend, looking into the current legal provisions in India, in the first state, and what could be the potential if there is a litigation. We'll also try and look into important because what is happening is that even if libraries have certain copies of the books, they're digitized and circulated to among their students is important. And in such a case, how would the doctrine of exhaustion facilitate such kind of access in the context of controlled digital lending? We'll look into the role and limits of copyright law to ensure educational access, primarily by looking into the compulsory licensing exceptions and how India has made use of the Blood Appendix. Into other kinds of alternatives that we have frequently talked about in terms of kind of ensuring access to copyrighted materials, and we'll try and ask a question whether if certain kinds of content in the broadcasting space can be regulated in terms of prices, could similar regulations apply in case of copyrighted content? And we'll look into one of the important decisions of one of the high courts, not the Supreme Court, and we'll see what kind of public interest provisions that collude directly with private rights are allowed in the Indian context, of course in the context of broadcasting, and we'll try and see whether they could have certain implications for educational use. And finally, the context of this particular discussion is also important because just a couple of weeks back, Indian government, the Copyright Office, issued a kind of private on its email group and asked for views on proposing amendments. Of course, the government itself has not come out with the draft yet. They are asking people to make submissions with reference to what could be the proposals. In that context, I think there could be certain things we could do with educational exceptions also, and I have certain recommendations. So the first thing, in terms of looking at the issue of education itself, you have the system of copyright as we understand, which looks at market rewards and hence price, and price discovery is only through the market. But education is a public good, and where education has to be equitable, and there has to be equitable access, and there is a direct dichotomy in terms of both price and access. But having said that, copyright is also a private property right, but could it be also understood as regulation? And one of the views emerged in the recent years is that copyright, although it's a property right, it's a leaky right, and the more emphasis should be in terms of regulating incentives for creating information rather than looking into it as a pure property right or a sacrosanct property right. This is more so in the case of educational use, because there have been arguments throughout many jurisdictions, including Canada and in India, as we shall see, whether fair use should become exception to the rights or should be a right by itself and in its own right, because there are different international that govern human right to free expression, to access knowledge, and in that context, what would it mean to construe education as an exception, or should we call it as a right? Should we look at fair dealing as comprising rights of people to access educational content? So in this context, it's also important to understand that India has right to education. We have also the Right to Education Act, but the Act does not directly deal with regulation of copyrighted works. And this seems to be one of the major loopholes in the current right to education environment, wherein the constitutional provisions do not tend to incorporating other people's work as forming part of right to education in terms of free access. So that's not covered within the Right to Education Act as such. But there are certain real-world constraints in which everything operates, and the real-world constraints, of course, are the industry, wherein the argument is if you weaken copyright, then the projects, and the investment towards those projects will always be for short-use projects and not, long-term and time-consuming projects where there is a praise for greater. This kind of projects will not come through if copyright is weakened. But the question is whether this is true in case of educational content, because educational content more or less are not in terms of long-lived projects, but are actually short-lived projects. And most of educational content is created by universities, sometimes largely by public universities, where there is a lot of public investment in those universities. The second kind of constraint is what is the role of the publisher in the self-publishing age? Because you have push-button publishing, you have digital publishing, but yet publishers seem to a lot of market share in the publishing space, primarily because of reputational effects. Academics still want to publish with big publishers precisely because of the kind of reputational effects and the kind of investment these publishers do. Not always, but sometimes large publishers do invest in and curating the content. Then third is the issue of open access, because right now, the way in which copyright law is structured, open access is voluntary in nature, because even if you are a firm that owns copyright, it's up to you to forfeit your rights, right? So open access is not created as a form of a mandate, and this is currently voluntary in nature. Although there are open access mandates within universities to publish in open access, but the right itself has not been curtailed to provide for more open access kind of models. And this model, open access model, has voluntarily been developed in the publishing industry, but with limited success, in the sense that even with open access, still there is a lot of scope to license copyrighted content. And that's what is happening, because even while more and more open access content is coming through journals, yet the budgets of the libraries are increasing year on year. And there seems to be some kind of practices in the publishing industry that have not kind of remedied or resolved the problem of limiting the budgets that libraries have towards procuring copyrighted content. So what has changed in the post-COVID scenario is definitely, everything is more digital, the digital classroom, and the kind of materials that you use, usually in the limited classroom context, in the physical context, is now in the digital environment, wherein today, if there are lectures that are conducted, they could be in an open access format, wherein not just students from your university, but students from other university could also participate. Sometimes these lectures are made on YouTube. Sometimes they are put up on common dashboards. People within the university and outside the university could equally access. So this has kind of created a different scenario, where previously the classroom would be, because of the physical limitations and because those lectures were not recorded, those were in time and space constraints. But now those constraints are no more present. This is also an end for the, and it means there is a need for creating digital copies of existing works and of future works, and that seems to be a remarkable shift. Those copies are not available, what do you do? And these problems are, well, since post-COVID, since the COVID scenario has, all universities have seen this because they could not provide students with digital copies of existing works in text that they had already procured. And some of the universities had many copies, yet without digital copies, it made little sense. Shifting focus is also towards open access and monopsony purchases. For example, there are certain universities which in India today mandate open access publishing, and the government of India recently has declared its intent towards monopsony buying, in the sense that they want to buy a subscription with all the publishers for the entire country. We don't know to what extent it is going to be successful, because publishers are definitely going to, fight back on this single kind of buying, monopsonic buying by the government of India on behalf of all the public universities in India. The important aspects of post-COVID situation in education has been recently highlighted in score by UNESCO. And it's very interesting that 2 points out of 9 emphasize on access to knowledge and information, and it really opens up the discussion again on open educational resources and access to those resources. But if you look into immediate amendments that were done in the post-COVID scenario, you would not find many countries really legislating to provide more open and digital access immediately after COVID. And the situation is still developing. India is one of the countries that has said that they would want to amend the copyright law, but we don't know in which way it's going to shape up, because there are going to be a lot of groups, different groups, which will put forth its interest. There was a recent joint proposal by South Africa to suspend drift obligation, and if you look into those the demand by India and South Africa, it says it's only in relation to prevention, containment, or treatment of COVID-19, and it clearly does not include educational access, unless we kind of interpret containment or treatment of COVID-19 to include some form of access. And interestingly, what it also says is that this kind of suspension is not demanded in case of performance rights or in case of broadcasting rights. But then India could also have, in the context of COVID-19, sought for suspension of copyright or in the interest of educational access, but it has not done so, because the joint proposal limits itself to prevention, containment, and treatment of COVID-19, and clearly educational access would not fall into this kind of formulation. So what is the current educational exception in India? We have private use or personal research, or personal use including research. That's one of the broadest forms of exception we have. And then you have reproduction of any work in the context, in the classroom, in the course of instruction. That is one of the major provisions that universities have towards ensuring access to educational works, and we'll try and see what has happened in the photocopying litigation between India's major premier university, that is Delhi University, and the publishers in India. Then you have performance of these works in the context of educational institution, but it is not in relation to reduction, but it's only in relation to. And you have certain other exceptions that libraries can exercise in terms of storing of work and possession of copies only in certain limited contexts. So if you look into the Delhi University photocopying decision, the facts in this case are clearly towards the question of whether course packs, wherein course packs would include different chapters from different formulated into one single compendium, and Delhi University contracted with photocopier as an agency to copy an entire volume of these course packs for all the students of the university. And they charged a nominal, the photocopiers charged a nominal amount, and they did make money in the sense that the use was commercial and not for profit. In this sense, what the publishers did was they asked that Delhi University should take a license from if they were to allow photocopying of course packs by this agency, that is the photocopying agency within the university. Delhi University initially was injuncted, but later on it contested the case. And in 2016, we had a very seminal and landmark decision that cleared the case around the educational exception or the fair dealing provision in relation to education. So one of the important aspects of this decision is that it has been clearly laid down in the context of this decision that copyright is a statutory right, and in this sense, there could not be any kind of natural law arguments in relation to copyright. That's very clear because the court really comes down on this argument that copyright has to be construed as a statutory right, and this, of course, the court bases it on the kind of the law itself, and looking into the provision, particularly section 15 of the Act, section 16 of the Act, and then it moves on to deal with the question of fair dealing. And what the court says is very interesting in the context of course packs, although the court does not clearly limit what amounts to taking for the purpose of course packs. In this context, it was shown that the photocopiers that Delhi University authorized had between 5 to 33% from different books. In one book, there was almost 33% of the book that was copied. In another context, the minimum was around 5%. In all, the range was between 5 to 50%. And Delhi University photocopying decision allows photocopying for the purpose of course packs. But it also says that they are not putting any kind of outer limit as long as there is a reasonable nexus between the kind of copying that is meant for course packs and the taking that is allowed. It does not want to impose any limits. Now, this gave rise to certain kinds of arguments saying full text photocopying was also allowed. Of course, the decision does not allow full text photocopying. It only allows photocopying of course packs, but the outer limit for how much those course packs can contain from each of those books is not clearly outlined in the decision. The second aspect of the decision is that if Delhi University can exercise this exception, its agency can also exercise this exception, because the argument of the publishers was that an agency cannot exercise educational exceptions because they are engaged in commercial photocopying. But what the decision allows is that if the very fair dealing exception is allowed for educational institutions, then institutions can appoint photocopiers to use these kind of exceptions. That seems to be very clear. The court also said that in the context of course packs and in the context of the ability of photocopy of all kinds of markets for license does not mean that fair dealing exceptions will not exist, because it's still possible to take license and pay certain amount to the publishers and then allow photocopying. But then the court said that such kind of interpretations should not be adopted in the context of fair dealing. They brought in the fair dealing exceptions to state that even if there is a market for license, it does not mean that fair dealing exceptions cannot be exercised in that context. So, which practically means that the argument that the publishers had taken, if there is a market for a license, which means if they were able to charge certain amount for photocopying for course packs, they should be entitled to receive the remuneration, was laid to rest by the Delhi High Court in this important decision. Of course, at that point of time, the publishers initially decided to appeal this decision and then later withdrew this. And that's why there is no Supreme Court decision on this matter. It did not go in appeal to the Supreme Court of India. But this decision has been given by one of the highest appellate courts in India, including the division bench of the Delhi High Court, which means it's a bench comprising of many justices. Having looked into this current educational exception, in the context of the Delhi University photocopying decision, it's important to question the limits of this decision. The limits of the decision definitely are that it applies only in relation to course facts. It does not apply to full text photocopying. And if it does not apply to full text photocopying, what would be the situation where you want to digitize in the post-COVID environment the full text of existing books that are available with the library? One system that has evolved in the recent years is the system of digital lending or controlled digital lending, wherein every time you lend, suppose if the library purchases 5 copies, and every time you lend those 5 copies, there will be only 5 simultaneous users. So, which means the previous copies will be automatically deleted. In that sense, if 5 copies are purchased, as long as the libraries lend it simultaneously and only 5 users are allowed at a time, libraries should be allowed to reproduce those copies. So that's the idea of controlled digital lending. But if you look into the Indian Act, it says the right holder, that the copyright holder has to issue copies of work which are copies not already in circulation, which means it allows for sale as long as the right to issue copy of the work is vested with the copyright holder. So in the context of controlled digital lending, the question would be whether by reproducing an additional version or copy an existing work, the library would be infringing upon the copyright holder's right to issue copies of the work. There are 2 interpretations of this, and two different jurisdictions have taken 2 different approaches. The US has a very restrictive approach wherein it has literally interpreted the act to mean that any kind of reproduction not authorized by the doctrine of first sale, but a Dutch court has looked into this method of controlled digital lending, and they have given a purposive interpretation to suggest that if a library has already purchased a copy, it could create another copy for the purpose of lending, as long as there is only a single simultaneous user for that single copy, which means copying or reproduction for the purposes of first sale would be allowed as long as there is only one simultaneous user. Now, this question is open in the context of India. As far as India is concerned, we do not have any case that has decided on the question of controlled digital lending. And there would be certain arguments in the course of time during the future amendments in the copyright law if an exception could be made in the context of controlled digital lending, and if first sale could include controlled lending as such. So that's one of the major lacunas in the current law which could be resolved in the future amendments to ensure that there could be first sale as applied to digital copies of existing works. The second issue is with reference to current limitations and exceptions. So compulsory licensing could be allowed in the context of literary work for works withheld from public. There are licenses for unpublished and published works. There are compulsory licenses for the benefits of the disabled. There are compulsory licenses in the context of publishing translations, and thanks to the Berne Convention Appendix, India has also implemented provisions in its law. And there are compulsory licenses to reproduce published works, literary works in certain cases. But what are the problems? The problems with the compulsory are very much constrained by the grounds. So the grounds would be sometimes in relation to whether the work has been withheld from the public or not, at what price the work is available. So all those would be, the grounds, constraints posed by those grounds makes compulsory licensing not a very kind of optimal formula for ensuring access, because it should be determined on case-by-case basis. Second, compulsory licenses are also constrained by conditions, because you have to go through voluntary negotiations. The field of use for compulsory licenses, sometimes exports are barred by the provisions of law, because if you issue a compulsory license, you cannot export. And hence, you could see that there are a host of conditions that impede the kinds of uses that you could make out of the compulsory. And there are also process-related constraints, because, as I mentioned, it's a case-by-case basis. for every kind of work, you will have to go and apply for a compulsory license, which makes it tedious for institutions to enable access to this scenario. So what then should be looked into? One of the aspects, in relation to educational access, should we really consider this as a market failure? If you consider this as a market failure, then we should really show that very high standard where so that there is no sufficient work that coming into the public domain, or that copyright is granted in a way where the arguments for property rights is limited only in a situation where people would create openly. The market would still provide abundant amounts of quantity of information or educational content. There could be other arguments in relation to ensuring educational access based on the principles of competitive harm, wherein if there are large monopolists operating in the publishing industry, competition law could intervene. There could be certain other kinds of public interest arguments. And let's look into this one by one. Statutory licensing, for example, has been visualized in the Indian context, in the Indian law, primarily for broadcasting organizations, that is for radio and TV. There have been recent attempts to extend the provisions of statutory licensing to internet intermediaries for publishing music or for broadcasting music, but they have so far not been successful. Would it then be possible that we could argue, in the interest of ensuring educational access, that a statutory licensing mechanism be created for digitizing content, and for easy availability of this content? The advantage of statutory licensing over compulsory licensing would be simply that you have already a statutory model wherein the way in which the royalties are to be fixed would be determined by the statute itself. The second is in terms of limitations of remedy. Now, if you look into the remedies operate in the context of copyright law, where you have factors that the courts look into in examining whether there is a balance of convenience, in whose favor of the balance of convenience, is there public interest involved. And if you look into these factors, definitely certain kind of infringement in relation to creating digitized content could be excused in the context of imposing civil remedies in the interest of the public, because in the post-COVID situation, definitely there is an argument that the library should be allowed to digitize existing works, which is in their lawful possession. The second kind of argument in relation to is the question of whether criminal remedies should at all be applied in case of piracy of educational content. Primarily because Indian law does not make any distinction between acts of infringement and acts of piracy. And acts of infringement and acts of piracy could be simply distinguished by looking into the kind of taking. If the kind of taking involves full digitization, then definitely it could be construed as piracy. But infringement involves taking bits and pieces of work from different works and trying to own work. But the Act does not distinguish infringement and piracy, and all kinds of infringement are construed to be made liable as a criminal offense under the Indian law. The Indian law also does not distinguish between piracy and piracy on a commercial scale. In fact, if you look into the TRIPS agreement, Article 61 of the TRIPS agreement requires WTO members only to require criminal remedies in case of piracy on a commercial scale. But India has moved a step ahead, and it does not define commercial scale currently, and it criminalizes all kinds of commercial piracy. Could there then be a case wherein, to ensure educational access, certain kinds of amendments in relation to criminal law could be introduced to determine both the nature of infringement and piracy and the distinction between these two, and also in relation to commercial scale? The third kind of argument in relation to ensuring educational access could be simple price controls. Currently, India has imposed price controls in relation to patented goods. Could there then be an argument to impose price controls in relation to copyrighted material in the interest of educational access to knowledge? I mentioned, if there are monopolies that are created by publishers, only when there is competitive harm, the competition law could intervene. But there is a strong argument in the Indian context in relation to regulation of copyrighted content. In around 2018, there was a decision rendered by the High Court of Delhi in Star versus DIPP, that is the Government of India, wherein the question was whether the Government of India could impose price-related restrictions on the content that was broadcasted by TV channels. And one of the arguments made was that since the Telecom Regulatory Authority of India is an organization that works in public interest, that is in ensuring consumers' interest, and also in regulating content in relation to broadcasters, and copyright being the public interest would prevail over the private right. And even though there was copyright broadcasting of content, still the right to determine the kind of pricing conditions could be determined by government through regulation. So this gives us kind of leeway in regulating copyrighted content even for the purposes of educational use. So there are many critics of this decision, but nevertheless, it gives us a strong argument if we were to have a kind of statutory licensing for the purposes of educational use or educational access to knowledge. So finally, I end my slide and my discussion by suggesting certain kinds of amendments and looking into whether the existing exceptions peddling uses could be extended to online education, and whether the limitations on Course Pack could also apply in the context of digital copying. If so, what would be the broader contours? Because in relation to photocopying, there is a limit on how much you could photocopy, but in the context of digital copying, photocopy is available online, that it could be easily disseminated. Second kind of amendment which we could argue is in relation to limiting the doctrine or expanding the doctrine of sale to apply for controlled digital lending, as we have seen. That currently is not clear from the Indian law. Perhaps clarification in the Indian law to allow controlled digital lending by expanding the doctrine of first sale could be helpful. And definitely, as I mentioned, because India allows regulation of content in public interest, that could be a strong argument for statutory licensing and controlled digital copying in the context of full text photocopying or creating of digital libraries. And finally, there is a requirement to layer remedies in terms of the principle of proportionality by distinguishing between infringement and piracy, and also by creating distinctions between piracy on the commercial scale and simple commercial piracy. So with this, I kind of lay down the broad contours of the discussion on educational use. I look forward to your questions, and thank you very much.
Okay, Yogesh, thank you very much for your presentation. It's time to finish our session. I don't know if you would like to present a final statement. Sean would like to make a final statement to Yogesh.
Oh, I'll just thank everybody for coming. I mean, this is a wonderful conference, as I said on the outside. I think, unfortunately, I've tried to look at the YouTube channels for questions, but I think we're not quite in the area where we can have a discussion with the audience. So I missed that with you all, but I'm very happy to be here and very happy for the continued collaborations that I think will follow this event for sure. So thank you very much for having me.
Thank you, Sean. I hope to meet you and the other professors, Yogesh and Francois too, personally next year. So it's complicated to keep all the time in the computer. I hope so. Biden this week, and people from the CODAIP next year. You guys would like to make some final remarks?
Oh, I'll just thank everybody for coming. I mean, this is a wonderful conference, as I said on the outside. I think, unfortunately, I've tried to look at the YouTube channels for questions, but I think we're not quite in the area where we can have a discussion with the audience. So thank you very much for having me.
Yogesh would like to make some final remarks. No. Okay, thank you very much. It was a huge pleasure to be with all of you, and I hope to meet you as soon as possible. Have a nice week, and if possible, take the track of the CODAIP. The sessions are being transmitted by YouTube and normally with English subtitles, so it's possible for everybody to understand, even when people is speaking in this spy language, Portuguese. Thank you very much. Goodbye.